So up next, we have Kimberly Kelley, is an attorney with Bickerstaff, Heath, Delgado, Acosta, LLP. Please welcome Kimberly. Thank you.
Hello, my name is Kimberly Kelley. I'm an associate at Bickerstaff, Heath, Delgado, and Acosta in Austin. Today we're going to talk about some frequently asked questions on the Public Information Act and the Open Meetings Act. So first we're going to just start with a brief overview of what these acts are. I saw there were a couple new directors in the room. And then we'll go through specific questions that frequently come up in our practice for each act, and then we'll look at a couple of criminal penalties if you violate some of these acts, so kind of the worst that can happen. So we'll start off. We're talking about the Public Information Act, which is Government Code 552, and then we're talking about the Open Meetings Act today. So both of these acts, as Steve mentioned, this is really about government transparency. So we're trying to keep it from the situation where, the conception that government is going on behind closed doors. Both of these acts were enacted specifically to combat that. So the first one is the Public Information Act, and this is dealing with tangible records, tangible government records, and the public's access. So the general rule is that the public has access to all of your government records. There are a couple of exceptions there, but the presumption is that everything is public. So the exceptions are specifically enumerated in the Act, and those are the only things that you can hold back when you get a Public Information Act request from a requester. So the standard is that government bodies have to promptly provide inspection or provide copies of these documents. So your threshold here is promptly. Typically that's within 10 days. That's how long you have to get with the AG and kind of figure out what you can hold back, but you do need to quickly provide access. So if you do think that something falls into an exception, and this can be things like certain law enforcement exceptions if there are active criminal investigations going on or certain information in personnel files. If you think that it fits an exception, you go through a process with the AG. You're drafting a letter. They're going to get back with you within 45 days, and you're going to follow their process until you can release the information to the requester. It may be redacted or whatever the AG says that actually fits an exception. There are a couple things that are previously determined to always be held back, something like a social security number or a birthday. But typically, the rule of thumb is that you can hold back things. You cannot hold back things on your own. You can release things. So you have to ask the Attorney General for anything that you're going to hold back. So next we'll look at the Open Meetings Act. So this is really the situation where you're in a public meeting. That's what this act was envisioned to rule over. We're going to talk about a couple of situations where if you're just meeting in maybe a social situation or something else where you still need to be cognizant of the act and make sure that you follow it. But it's trying to make governmental decision-making accessible to the public. So the presumption here, again, is that everything should be public. And like the Public Information Act, there are certain things in the Open Meetings Act where you can have a closed session and you can meet outside of the eye of the public. There are not many. It's things like meeting with your attorney if you're talking about litigation or something like that, or certain personnel reasons. But for the most part, everything needs to be done in front of the public. Public notice before a meeting is required. You have to have 72 hours in advance posted notice of your agenda items, the date, the time, the location of where your meeting is going to be. And then just again, that act is liberally construed in favor of open government. Both acts are. So we're really trying to provide access here. So now we'll look at the Public Information Act specifically. So some frequently asked questions here. The first, So if someone writes in a request to your district and they're asking for a document that does not exist, say maybe they want the number of exempt wells that you have, just as an example, and you don't actually have a document that lists that. You would have to go and count. What do? Do you have to create a record that answers their question? So the answer there is no. You don't need to create a record or create a document that does not exist. The point of this act is to release documents that already do exist, so you don't have to do things like compile statistics or perform any research or actually even answer a question. You just need to provide them with all of the relevant documents that you have so that they can answer their own question. That being said, if it's easier, rather than producing 2,000 pages worth of something so they can piece that together, you can create a document, or you could simply count and answer the question. Be careful there. Make sure that you're actually giving them what their request encompassed. If it is something where they wanted all those documents, you need to give them all of those documents. So what if someone is repeatedly making requests or making very large requests, and it's to the point of harassment? Do I have to keep responding? So this could be a situation where maybe they're requesting the same information over and over, or they've made a standing request that they want you to comply with all the time, or they're just requesting a very large amount of information. So we'll look first at the repeated requests. Do I have to keep responding? The answer is no. If they keep asking you the same question over and over, there's a provision in the Act that says that you can essentially send them a letter that's certifying that you've already answered this question. I think there are 5 things listed in the statute that you actually need to certify, but the gist is we already provided this information. Let them know when you provided that information, and assure them that no new information has been generated since the last time they asked this. So if someone is making very large requests and it's to the point of harassment, do you have to keep responding to these large requests? So the answer there is not always. There's a section in the Act that allows your district to enact a policy. You can adopt a resolution that essentially limits the personnel time that you're spending on this one requester's requests. You don't have infinite personnel time. It takes people and money to actually produce all of these documents that they want. So if it's to the point where they're a vexatious requester, after a certain amount of time, you can impose costs on them that they're going to have to pay up front before you continue to comply with their requests. So we'll look at an example policy from one of the partners in our firm. So here you see at the top, it's establishing a yearly time limit of 36 hours. So 36 hours per 12 months, or 15 hours per month until you reach that 36 hours. So you can establish a policy like that, and once you hit that 15 hours after 15 hours spent on that one requester, you can provide them with a written total estimate of the cost that you think it's going to take to comply with the rest of their requests. So if you think it's going to take 100 more hours, you'll come up with whatever number that's going to come out to be based on personnel time and your resources. Provide them that written estimate, and then they're going to have to pay that amount up front if they want you to actually comply with their request. So that's a little tool that you can use in case someone is really just harassing and taking up all of your district's time. So this is a big one. What if you use your personal email address to conduct district business? Is anything on a personal device, a personal cell phone, if you're texting between directors, is any of that subject to the Public Information Act? So the answer there is yes. So any public business that's conducted on a personal device is still going to be subject to disclosure. So the standard here is public information includes electronic communications that are on any device, and it's the transaction of official business. So really what they're looking at is the nature of the communication. It really doesn't matter what sort of device or Twitter or Facebook or whatever you're using in order to conduct official business. If the nature of the communication is in the capacity as your role as in the capacity of your role as a director, then it's going to be subject to the act. So we'll skip that real quick and look at an example of that. So this happened in May in Austin. This was the AISD board president. So she was texting back and forth with I think it was a board trustee, but it was some other employee in the school district. And she had written she was talking about official business, but she just used some choice terms, and she called some people crazy and ignorant and a bunch of different things. So it came out in an open records request, and it was embarrassing to the point that she had to resign. But I'm sure she felt that she was sending it on her personal device. That really is going to be subject to the act. So one thing that I wanted to point out at the bottom here, there's a section in the Public Information Act that is a confidentiality election. Staff and public officials make this election through your district within 14 days of your employment or election. So this is something that allows you to hold back your home address and home telephone number and some more personal information. I think it's also any family relations that you may have. So you have to make a specific election to hold that back. If a Public Information Act request comes and that information might be released, you need to make sure that you do that ahead of time, because it doesn't work retroactively. You can't get the request in and say, oh, I don't want to release this, and then sign an election really quick. You need to make sure that that's on file with your district. So now we will look at the Open Meetings Act. So we kind of touched on this a little bit. What if a member of the public asked me a question at our meeting? Should I answer? So this is the same situation that Steve was talking about, the public comment section. So you can or cannot have a public comment section, but most people do. So if they do get up and ask you something that is not on the agenda, you should not answer. It's very tempting, like we talked about, to try to be transparent, and in the name of transparency, maybe you want to discuss that. But at this point, if it's not on the agenda and they're getting up and talking about it in a public meeting, you basically have 4 options. So you can talk to them and share basic factual information. You can share the existing policy of the district. You can refer them to staff, or you can tell them that you're going to place this on a future agenda item. So I think typically it ends up on a future agenda item. Another thing that you can do is after the meeting, you could talk to that person if you really feel like you need to address it then, but you cannot do it as a government body. Really, they can go talk to staff about it. So this also can be used as a shield because you cannot talk about it because it was not posted. It may be an issue that's sensitive or uncomfortable, or just something that you don't have a policy on yet, and you're put on the spot in a meeting. You honestly can say that you cannot talk about this because it has not been posted. And then just some other advice: if it was posted on your agenda and it's agenda item 17 or something, and they get up in the beginning in the public comment section and they're talking about it, one thing that we recommend is we ask those people to wait until the actual agenda item is called, just for it makes your meeting go a little bit more smoothly, because like Steve was saying, you don't want people they're fresh at the beginning, and you really just want to make sure that you have an orderly meeting, and that's one way to keep it orderly. So if we are hiring an outside professional, can we discuss that in executive session? So if your district needs to hire an independent contractor of some kind, be that a groundwater consultant or outside legal counsel or whatever it may be, typically, if you are talking about your own personnel, your own staff, you can talk about that in a closed session so that you're not talking about employment matters in front of the public. But if they're an independent contractor, the answer is no, you cannot. So that you still need to do in a public session. So you can Only talk about the employment of a public officer or an employee when you're alone in closed session. So next, if my fellow director texted me during a meeting about official business, is this going to be okay? Maybe you're all sitting in a meeting and someone shoots you a text from across the way. It's obviously not public at that point. So this could be a group message or just an individual message. So no, that is not okay. During an open meeting, all communications should be public. You could probably talk to just one other director, but the problem with that is, one, it can subject you to Public Information Act requests, because now you're making a public record that it's about official business, so this could come up again, and people can ask what you were talking about. And probably if you're texting one another, it's not something you want to say out loud, so that's not great. But two, you don't know if you just text one other person. It's so easy to create a group message or for someone to forward on a chain of what you've said to everybody else. So you really create an open meetings issue if you start to do that. No problem. So that kind of goes into the walking quorum issue. So a walking quorum is when members of a governmental body meet in a series of meetings that is less than your quorum. So say your quorum is 4 people. If you meet in groups of 3 in order to circumvent the act, that's not okay. And we'll talk about some of the penalties there. But know that if you start getting into texting and electronic communications, that could be a walking quorum. It can be over any kind of social media, texting, email, whatever it may be. It's not limited to just actually having a verbal meeting in person or over the phone. So we have a best practice there. You're trying to avoid the situation where you send an email to all of your directors, you need to communicate something to them, and somebody hits reply all. Instantly you have an Open Meetings Act problem. If people start to talk about official policy or whatever it may be, you now are having a meeting over email. So a good way to avoid that is to do the following. So you can write an email and send it to yourself, so that's me up there, and then you can blind copy all of your directors. So if it's something like here, it would be a litigation update. I would also put that this would be attorney-client privileged in the subject, and then have a disclaimer here that asks the directors to please not forward this email or discuss it with anybody except for in a public meeting. And then go ahead and disclose that all of the directors are blind copied. But if you're blind copied on an email, you cannot hit reply all, because we've all done that, accidentally hit reply all instead of reply. So this can save you from doing that. So this is something that came up because of Hurricane Harvey for one of our districts. This is if somebody properly posted a meeting, but then a catastrophe occurs. Maybe there's, in this case, flooding or a rainstorm or a fire or something like that, and you cannot get to your meeting place. Can you still meet? So the answer, yes. There's an exception in the Act that is talking about if you can still meet within the next 72 hours, then you're allowed to do so without reposting the meeting if it's in the event of a catastrophe. If you can't meet within that 72 hours, then you must renotice the meeting and go on as usual. But during that 72 hours, you can basically follow the emergency meeting guidelines, like gives 2 hours of notice, and still meet. So now we're going to look at criminal penalties violating the acts. And I think I'm running short on time, so I'll go pretty quickly. So the first is the Open Meetings Act. So there's 4 violations here in the Open Meetings Act. The first one is that walking quorum that we talked about. This is when you're conspiring to circumvent the act by meeting in smaller groups than a quorum. You cannot do that. And as we talked about, electronic means of communications count. So the next is unauthorized closed meetings. So there are only a few enumerated reasons that we talked about that you can actually call a closed meeting, like those personnel reasons or whatever it may be. So if you are knowingly participating in a meeting that is not open to the public and it's not for one of those reasons, they're violations. So the next one is when you are in a closed meeting, that meeting either has to have a certified agenda where it kind of describes what you have done in this meeting without, revealing the subject matter that is closed, or you have to have a recording of the meeting. So if you are knowingly participating in a meeting where one of those two things is not happening, that's a problem. And I wanted to talk about unknowingly participating in a closed meeting, the second one. So if you're not sure if you can have a closed meeting, you can ask your attorney. And it is an affirmative defense to this violation if you asked your attorney and they gave you their opinion in writing that you were able to have a closed meeting on that topic. But it does have to be in writing. I know there was a case out of San Antonio a couple of years ago, and during a meeting, they verbally asked their attorney if they could have a closed meeting. The attorney said yes, they did so, and they were later sued. And it turns out that the AG has specifically said you have to get that in writing from your attorney. So make sure you do that, even if they're just shooting off an email while you're in the meeting. And then the fourth is that certified agenda or recording that we talked about, you cannot disclose that to the public. That really can only be released by court order, the contents of that recording. You can talk about what happened in a closed meeting. There's nothing that says you can't do that. That being said, it's not very advisable. It's a closed meeting and closed subject matter for a reason, and you need to be careful doing that because if the closed meeting was, say, to talk to your attorney, you could be breaking attorney-client privilege if you go and then talk about what happened in the meeting, so just be careful with that. So some of the things that can happen, so fines up to $500, 6 months of jail time, misdemeanors, and lastly, some of these are official misconduct, meaning that it would be grounds to remove you from office. So these are really things that we want to avoid. So sometimes at events or such, you have a possibility of a quorum or a walking quorum. In fact, do any of you have a quorum of your directors at this event? Okay. So that actually is fine. There are exceptions for social situations and conventions and workshops and some public hearings where you can have a quorum of your directors present. The two things that you can't do, you can't take any official action, and you can't have any policy discussions other than what is incidental to the event that you're in. So like say, if you wanted to make a comment in one of the bigger sessions when we have the question and answer time, and you want to get up and talk about a policy of your district and it's incidental to the event, but all of the other directors are there, that's okay. But if you wanted to go to lunch and talk about what's on your next agenda, that's not okay. That would be an improper meeting. But one thing that you can do here is you can post a notice of a possible quorum. So here's just an example. If you know that you'll be here and you know that you might have a quorum, then you can just say that the city council might be present or the board of directors might be present, but no action will be taken. And just go ahead and post that anyway. So here is an example. This is being weird. Okay, so an example of an Open Meetings Act violation. So this happened a couple years ago with the Austin City Council. They were in open meetings and IMing each other from their seats. So they launched an investigation, and they ended up having to look through notes, texts, emails, cell phone records, and other documents. And they, as you can see, they said every modern communication medium that exists, they were using to violate the Open Meetings Act. So this really just hammers home that it can be anything. And all of your personal, like if you're using your personal device to conduct official business, one, we would recommend that you have a separate device that's only public business, and that you have a separate email address so that you can keep all of these separate, because somebody had to go through those 30,000 pages of all these notes and emails and personal things in order to figure out if they violated the Open Meetings Act. So if you have that all in one place, that's a much better policy. So then the Public Information Act. So there are three crimes here. If you're destroying, removing, or altering public information, so if you are conducting business over text and you're then deleting those texts or deleting those emails or do anything like that, that can be a violation. You can only delete things in compliance with your record retention policy. So you should have a policy on file that says, you know, such and such has to stay around for 7 years if it was litigation or after a case settles or whatever it may be. And so you'll only delete things in compliance with that policy. So next is misuse of confidential information. So that's releasing things that you shouldn't under the Public Information Act. That would be like if you got a request in and somehow you had, you know, like a sheet of Social Security numbers or something, and you ended up just releasing that instead of going through and redacting it. If you release that with all the other documents, that's not good. And then lastly is a big one. So this is failure to provide access to information under the Act. So this is when you're specifically holding things back, maybe that you don't like or you just don't want the public to see. So that's fines up to $4,000, 6 months of jail time, and again, official misconduct. So we'll look at a quick example there. This happened just last month. So this is the city of Houston. It was the mayor's former press secretary. So I guess she was conducting a lot of personal business on her public email address and spending a lot of, you know, public time for her personal gain. So she got a request. She was the press secretary. She's the one that received the request from a reporter asking that she release all of those emails, and she did not. She held all of them back. So she's actually been indicted, and she faces 6 months of jail time and a $1,000 fine, I believe, and lost her job. So lastly, I just wanted to mention that Open Meetings Act training is required. So it is required by the Act, and the Attorney General has to provide you with 1 hour to 2 hours of free training. So you can access that online. You do have to take that 90 days within taking your position or taking office. There is also training for the Public Information Act, but if you have a designated public information coordinator, they can take that training and that will suffice. And then I wanted to note this training does not count for that today, so you still do have to go watch the AG's presentation. So lastly, just the takeaway is just never put anything in writing unless you want to see it on the front page of a newspaper, because in researching this, I've read a lot of things that public officials have said that really shouldn't have happened. So that's it. Yes, sir.
So I know it's a quick, we're running late, but is there a possibility that, you know, for five district commissioners, that 1 or 2 could Skype to still be able to make a meeting, or is it automatically got to have 3 present? I understand there's been some issues on that, I'm not sure.
So you can video conference in. I think you still have to have a public space, and you still have to have a person present. So it still has to be accessible to the public, but there are laws now that you can video conference in a certain number of people. I would need to look up how many.
There has to be a quorum in the public area.
Right.
Other members can Skype in at that point.
Yes.
Well, and it's not just Skype, it has to meet the special laws of the state on.
You have to have certain equipment, and yes.
And the presiding officer has to be at the meeting.
And the presiding officer.
It can't just be a phone conference.
It can't just be a phone conference, right? Yes, sir.
Since they involve criminal penalties, could you kind of run through a quick list of what is held confidential? Because I think email addresses are on that list. And when you get a request for all emails related to,
Mm-hmm.
you better go through and redact every email address
So-
of a member of the public before you give it up. Because giving that up without doing that is a criminal violation.
So there's specific rules for email addresses. So members of the public that are interacting with the district, I believe you redact those email addresses, but there are 5 instances under the Act where you may still need to release them. That's like if they're engaging in, if they're in some kind of employment situation with the district, but those are specific and laid out in the Act, what you need to comply with.
So besides social security numbers, email addresses of the members of the public, what other types of confidential information are there?
So it's birthdays and fingerprints, and I think W-9s are in there, and there's all kinds of, I can get you a list of it.
I wanted to highlight for everybody, there's information that must be must be released.
Mm-hmm.
There's information that may be withheld. There's confidential information that there's a criminal penalty if you release it. So make sure you understand the different categories of public information.
Yes. Thanks.
If you give him a list, he's just going to resell it at Mark.
All right, I'll avoid that then. Great, thank you.
Questions?